there. So very interesting questions will come up for litigation in many countries, I'm quite convinced. And you have also again a 365 days rule, which is understandable because right now this Article 13 paragraph 4 was very easy to circumvent. If you, at the day when you sold the shares, if you made sure that the asset structure just fitted or did not fall under Article 13.4 because you sold some of the movable property or you bought other assets, then you were out of Article 13.4. So therefore it's also this long-term perspective which should prevail. 365 days should be relevant. Then one other provision which should come into the treaty, the tiebreaker rule we have under Article 4, paragraph 3 of the OECD Model Convention shall be changed. So far, we have as a tiebreaker for legal entities the place of effective management as a criterion. So therefore, if we have a dual resident company, which is, for example, incorporated in one state and has its place of management in the other state, then the state where the place of management is located should prevail. That's the rule as it exists today in the OECD Model Convention. And the OECD is quite skeptical about dual resident companies because they feel they are very often used for tax planning purposes. So therefore, they want, in cases of a dual resident company, they want to make the treaty application dependent on a mutual agreement procedure. Yeah? So therefore, either there is a general mutual agreement between the two countries which provides for the criteria which are relevant, or if there is no mutual agreement, no general one, then in each case, when you have such a dual resident company, you would have to approach your competent authority and ask for treaty entitlement. Yeah, so it's also a kind of grace clause, as I would call it, because you very much depend on the administration, which I think is also a trend here under these provisions. We find quite often, and this is an example for that, where powers are delegated to the governmental authorities at the end of the day. Yeah? So you really depend in such a case then that your competent authority agrees here and that there is a mutual agreement reached at the end of the day. This is not completely new. There are already some tax treaties around which contain such a provision, like some of the Canadian tax treaties, for example. However, I think it's not ideal because it complicates matters. It's of course true that dual resident companies are often used, or had in the past at least, been used also for tax planning purposes. However, that's not always the case. Sometimes it just happens that you wake up with a dual resident company, you have not intended it, but then a place of management shifts to the other country because a lot of board members are in the other country, they meet in the other country, and suddenly you wake up with having a dual resident company. That might happen as well. Yeah, you have all kind of troubles already, and then in addition to the troubles you have already now, you wake up and find out that you don't get treaty entitlement anymore, and that you have to approach your competent authority and ask for grace there in such a situation, which I think under the rule of law is not really ideal. Then the OECD proposes to include in the treaty a specific anti-abuse rule for permanent establishments situated in third states. And they want to deal with a specific problem, which is mainly a problem under the exemption method. Just think about the following triangular situation. You have a resident state, and then you have the company, which is located in the resident state, has shares from and receives dividends from another company located in another state, and those shares are part of the permanent establishments in a third country. So you have that triangular situation: resident state, permanent establishment to which the shares are attributed, and the dividends come from a third country. And here, quite often, you might have, if you are in the right, if you have your permanent establishment in the right state, in a low tax jurisdictions, then you might end up with double non-taxation, or at least very low taxation, because if you have the exemption method between the state of residence and the permanent establishment state in place, then if the shares are attributed to the permanent establishment and therefore also the dividends are attributed to the permanent establishment, then the resident state is prevented from levying any tax. It's only the state of the permanent establishment which may tax, and if there is low taxation, well, then there is neither taxation in the state of residence nor in the state of the permanent establishment. However, you can still apply the tax treaty between the state of residence and the source country in order to reduce withholding taxation. And that's the point now here. So the OECD wants to make sure that you don't get the full limitation you usually get in such triangular situations. So therefore, the OECD deals with a very specific triangular and anti-abuse provision here in that context. And which I think is understandable to a certain extent. However, it's also the case that the OECD Model Convention does not fit really for triangular situations. We have a lot of problems with triangular situations, and therefore it's maybe not that consistent to deal with a very specific triangular situation without having dealt with triangular situations in general. Yeah, I'm coming to the end now, so tried to touch at least the most important provisions which might be changed. As I've promised, or I haven't promised more than I will just raise questions here, put them on the table, so maybe they were a bit thought-provoking. I think what we see, if I may summarize, that we have many proposals on the table, but the speed the OECD has in the whole PEPS project is enormous, and I think there is the risk that we really lose quality at the end of the day, because not all of these provisions are really very well thought through. So I think it would be worse maybe to spend 1 more year or 2 more years also on thinking those provisions through before we really implement them in the OECD Model Convention. However, the time schedule is there, so I would not be too optimistic that the time schedule will change, because the politicians want to have results at the end of the day, so the governments and the civil servants in many countries are under pressure. However, what we see when we look at these provisions, that the OECD already acknowledges that some countries might have problems with one or the other provision, and they almost encourage countries in their draft commentaries to come up with bilateral changes, therefore, and which is not good either, because I think the value of a model convention is that we have the same provision all over. And if the OECD now invites member countries and also non-member countries to deviate from this from the model conventions, well, what is the value of the model then at the end of the day? So therefore, I think this kind of flexibility, also flexibility always looks nice and sounds nice, but I think in that respect, flexibility is not the ideal solution. And it's also not ideal, as I've tried to demonstrate, that a lot of discretion is given to the administration, because under the rule of law, I think it's not ideal that more or less not only the interpretation, but also clarifying a lot of tax treaty issues will be in the competence now of competent authorities or of governments as such. Yeah, but I think what's definitely true is that we are living in exciting times here, and that I think we have to deal with those issues right now in order to be prepared for the future. I think at the end of the day, most of them will be implemented if we like them or not, so therefore it's better to be proactive and think about them right now and not wait to discuss them. Thank you very much for paying attention.
Thank you very much, Professor. Friends, this subject of BEPS is such that we can take a whole week and we would not have finished it. Sir, in Hindi we have a proverb that the entire ocean is put into a pot. Sagar mein gagar. Professor Lang has in 1 hour given the glimpse of so many issues which are involved in BEPS. Friends, because of lack of time, I will not make any further comment, and question answer session is also dropped. Mayur Bhai will give vote of thanks and then we'll break for a cup of tea.
Friends, all of you are aware that Professor Michael Lang is here to attend IFA and has a very tight schedule. But when we approached him to address our gathering, he readily agreed, which shows his love for the subject, love for the profession, and his willingness to share his knowledge with us. Today's presentation, with his experience and exposure, became very interesting and informative. I, on behalf of all of us present here, on behalf of BCAS and on behalf of CITC, propose a very well-deserved vote of thanks. We break for 10 minutes. 10 minutes. Thank you.
Sorry to break it more. Thank you very much.